5 seconds to go. Start. The tribunal relied firstly upon certain observations of this court in Popular 2 and secondly that PW1 had no authority to admit any fact to the detriment of the state. Likewise, the tribunal rejected other documentary evidence in the form of Exhibit A11 and A14 as well as Exhibit A6 and A7 as insufficient to prove that the disputed properties were principally planted with rubber, coffee, or cardamom. In the final analysis, the tribunal went by the fact that the disputed properties were covered by the Madras Act immediately before the appointed date. It consequently held that Popular Estates failed to bring their case under any of the clauses to Section 2F11 of the Vesting Act, that is, the exclusionary part, and therefore failed to prove that any part of such properties were estates meant for the cultivation of coffee, rubber, cardamom, etc. Aggrieved by the tribunal's order, Popular Estates preferred an appeal. The High Court, in the impugned judgment, recounted the entire proceedings, particularly the judgment of this court in Popular 2 and the decision in Kunjanum Antoni Supra. It gave certain weight and credence to the observations and findings of the board and held that the land sealing proceedings were not res judicata in the proceedings under the Vesting Act, but constituted a valid piece of evidence. The impugned judgment relied upon the judgment in Kunjanum Antoni's case supra that until a contrary state of affairs is shown to exist, the order of the board would have to be given due weight. The High Court observed that the excess land automatically vests with the state, like in the private forest vesting under Section 3(1) of the Vesting Act. The purpose of or intent of both enactments is to distribute excess lands to landless agricultural laborers. The High Court was of the view that the state never alleged that the board's order was obtained under fraud, but rather that it was passed after considering all statutory formalities. The board noted the High Court rendered findings with respect to the nature of the land as on the appointed date of the KLR Act, that is 1st January 1970. The appointed date for the Vesting Act was 10th May 1971. The High Court held that there is not much difference between the two dates in point of time and that there was nothing on record to suggest that the land usage had changed in between. Proceeding with its analysis on the evidence on record, the court took note of the title deeds Exhibit A37 to A40 and the balance sheets and profit and loss account Exhibit A59 to Exhibit A64 to show that Popular Estates was earning agricultural income from the land before the appointed date and that it maintained regular balance sheet and profit and loss account. The High Court was of the opinion that the notification issued on 8th July 1977 ultimately led to the state establishing that only 100 hectares were private forest. It was also stated that Exhibit A27, that is, the notification dated 22nd July 1987, was issued after demarcating the land under Section 6 and taking those 100 hectares as included in the 1534.40 acres purchased by the firm after 9 years when legal proceedings were pending. Exhibit A65 is the accounts ledger for 1970-71 which showed that there was cultivation in the relevant accounting year. there were other letters in the form of exhibits, that is exhibit A66, A69 and A70, which showed that labor authorities such as the Labor Commissioner and Provident Fund authorities were involved with respect to labor unrest in the state. Exhibit A67 and A68 were addressed to the Agricultural Income Tax Officer, and Exhibit A71 and A72 were letters addressed to the Sales Tax Officer. These also showed that some labor disputes in the state starting from 1983 existed and that production had slowed down. It was only after this that Exhibit A27, notification dated 22nd August 1987, was issued. The High Court was of the opinion that all these documents clearly showed that the entire area other than the 100 hectares of land earlier notified by notification dated 8th July 1977 were not private forests on the appointed date but exempted in view of the definition of private forest. The court stopped.